The first case this afternoon is case number 167300, Michigan Immigrant Rights Center versus Governor. This is a mini oral argument on the application. Both sides will have 15 minutes. Appellant, if you'd like to reserve some time for rebuttal, we just ask that you keep track of it. And then we both of you will have a 2-minute free fire, and which you can waive. So, when you're ready.
Good afternoon. David Maraskin for Plaintiff Appellant, Michigan Immigrant Rights Center. I'm going to endeavor to reserve 3 minutes for rebuttal. In Michigan, undocumented workers are automatically denied wage loss benefits. Merck sued to stop the present and future enforcement of this policy because it is unlawful and unconstitutional. The Court of Appeals did not reach that issue, none of the merits issues. It dismissed this case based on the theory that the governor could assert sovereign immunity against that claim, and therefore Merck needed to fall within a waiver of sovereign immunity, MCL 600.6431, and it failed to do so. Our briefs and our amicus briefs provide numerous reasons the Court of Appeals decision is wrong and dangerous. I'm going to focus on 3 issues why the court should hold as a matter of law the Court of Appeals should be reversed. First and foremost, the governor cannot assert sovereign immunity against this case. It is the providence of this court and the courts of Michigan to say what the law is. In our tripartite system of government, that means the courts can always order government officials to comply with the law going forward. There is no sovereign immunity to be waived in this case. Leaving that aside, whether or not MCL 600.6431 is a waiver of immunity or just a statute of limitations, Merck's case does not fall within its text. MCL 600.6431, like so many other statutes of limitations, is concerned with stale claims, claims that occurred in the past. Merck seeks to preserve its rights going forward, and that forward-looking relief does not fall within the plain text of the statute. The statute seeks to bar claims that were filed, quote, 1 year after they accrued. Finally, but relatedly, the statute only applies to claims against this state. The governor is not the state. She is an officer of the state, and the Court of Claims Act expressly distinguishes between the two. You can reverse on any one of these grounds, but we encourage you to at least reach the immunity and textual issues because the governor has been playing a game throughout this case. She has insisted on immunity up to this court, and that is why she's been able to delay this case for years by getting interlocutory appeal by claiming immunity. Before this court, she abandons that argument and says she proceeds on the text. To avoid that sort of gamesmanship, we encourage you to address both issues. I welcome the court's questions.
I'm struggling with, seeing this. I understand that you have named the governor as an individual officer, but if you are afforded the relief you seek, it is the agency or an agency that will actually implement that relief. So why shouldn't we be looking at the governor in her official capacity as the equivalent of the agency?
Well, so a couple of different answers there. The governor in her official capacity is distinguished between this state, so textually those two are different. The governor is also the individual responsible for the determinations of the agency, and this is pled in paragraph 26 of our complaint. She is responsible both as a matter of law under statute, as we detail in that paragraph, and also, as Duncan explains, as in her responsibility to take care of the laws, she's ultimately responsible for the agency. So she is ultimately responsible, and that's how you sue in the official capacity. And if your question's about immunity, if that's what you're getting at, if the question is whether she can assert immunity because ultimately the office of the state would be held responsible, this is what the whole exception of sovereign immunity is about. An officer who is acting unconstitutionally, unlawfully, cannot be the state. And so to the extent she is acting unlawfully, and she is with this policy, she is responsible for that, and she can be enjoined by this court, and then she can be required to act accordingly, which means enforcing her views against her subordinates who are under her responsibility, as we plead in paragraph 26.
So she would be that for every agency in the state government, correct?
I believe that's how I would read Duncan, yes.
And I guess that's where I struggle, like in name, she's not, but you're saying that yes, in fact, she is the state.
What I'm saying is that for the purposes of sovereign immunity, when she's acting unlawfully, she cannot be the state. And therefore, even though she is responsible for all the agencies, she can be named in her official capacity as the governor rather than suing the state.
And you think that the legislature sort of understood that nuance in the words it chose of leaving officer out of 6431, but including it in others, that was an intentional?
That is how I think the law requires us to interpret the statute, that as Pike explains, the statute says this state, and the rest of the statute distinguishes between the two, and therefore the legislator is presumed to understand that distinction. But again, even if you were to disagree with that, you don't need to agree with us on that to resolve this case in our favor. She does not have immunity, and we fall within the statute even if the governor is assumed to be the state, because we are seeking prospective relief and also insert claims that were filed within a year. But I think it's important to understand the gravity of what the governor is saying here. Suppose she had a policy that said she read some 1980s Supreme Court decisions and thought, they were really right on anti-sodomy laws. The state of Michigan, which still has an anti-sodomy law on its books, can enforce that. And I'm going to ignore the intervening U.S. Supreme Court precedent, Lawrence v. Texas, that says you can't enforce that because that's unconstitutional. That is absolutely no different than the policy she has here. And her position here is that unless the legislator waives immunity, she can escape any liability for that claim, a claim saying that she cannot enforce anti-sodomy laws, and that only if you bring a claim within 1 year of when the policy begins can you ever enforce it. Can you ever enforce your rights? So a person who suffered under Michigan's anti-sodomy laws for a year because they were scared to come forward, they couldn't find a lawyer, in the governor's view, she can then enforce those laws against that person indefinitely. A prisoner whose warden says you have to be in solitary confinement the rest of your time, and who can't find a lawyer within a year, perfectly logical circumstance. And in the governor's view and the Court of Appeals view, that person can be held in solitary confinement and could never be able to bring their claims after a year, because she is the state and you have to bring a claim within a year. That is not how statutes of limitations work. It's not how sovereign immunity works. We're talking about prospective relief. And the governor under sovereign immunity can always be required to follow the law. And as this court has held in Taxpayers and Haney, it has said that you can always seek prospective relief under statutes of limitations like this one. My colleague on the other side is going to get up and try to make some confusion. He's going to say this case isn't about prospective relief, it's about a past decision. That is simply factually false. It's ignoring the allegations in this complaint that must be taken as true. Paragraph 1 explains the governor has an active policy to deny undocumented workers compensation benefits. Paragraphs 80, 81, 82 of our complaint explain how that active policy harms Merck. That active policy diverts workers out of the workers' compensation scheme and sends them to Merck and imposes costs on Merck. These are costs that we allege Merck has never intended to absorb, and they're costs Merck incurs today and will incur tomorrow. And Merck has said that Merck explains in the complaint, that if the governor got rid of this policy tomorrow, its costs would end. What's happening is that the private bar is unwilling to take these cases because the governor is enforcing this policy. This is not about some long ago decision. This is about the governor's decision today to enforce the policy, which is telling the private bar, we're not going to hear these cases, and sends these people to Merck. The policy goes away, this case goes away. And that's what prospective relief is about. That's all we've pled, and that's why we can proceed.
Counselor, I think Brother Counsel would also say that even if there's not a question of sovereign immunity, that the statute is a condition of the forum. And so why, if you're seeking prospective relief that hasn't been attached to a past harm, would you not be required to comply with rules of the forum if that's how they view the statute?
And I think there are two answers to that, both different ways we've complied with those rules of the forum. What this court has said in Taxpayers and Haney is that that rule of the forum that says you have to file within 1 year after the claim accrued is about stale old claims. So when you're seeking prospective relief, it doesn't apply. Taxpayer says you don't even need to think about that. Haney says as a matter of law, your claims for prospective relief constantly reaccrue because you're constantly faced the continued enforcement of the policy and a renewed harm, or I know continue is a complicated word here, a repeated enforcement of the policy and renewed harm. And so we fall within that, the statute that way. But we also actually pled a harm within a year of when we filed. This case is now 4 years old, but if you look at paragraphs 80 to 82, we explain that in the year prior to filing this complaint, the governor had her policy that directed workers to Merck. Merck absorbed those costs. Those were costs that were real, and that occurred within the year. So even if we have to somehow bend space and time to say that we've had a claim that accrued within 1 year, but our real concern is about the future, we fall within the statute. And so that's leaving aside this state issue that I was talking with Justice Kavanaugh about, where we think the text can be read to exclude the governor. If there are no further questions, I'll reserve the remainder of my time. Thank you.
Great. Thank you. Mr. Fish.
Good afternoon. May it please the court. Assistant Attorney General Gallant Fish on behalf of the governor. With me at council's table is Assistant Attorney General Chris Braverman. Your honors, the novelty of the claims at issue alone cautions against using this case to break any new ground in Michigan jurisprudence. Merck seeks to overturn binding case law using declaratory judgment action brought against the governor of the state of Michigan for her role in workers' compensation proceedings. Meanwhile, as in other administrative matters, an appeal from a denial of benefits is available through which Sanchez can be challenged. But should this court reach the questions raised in this order, those answers are straightforward. 6431 does apply to claims for prospective relief against state officers because a claim against a state officer in their official capacity is a claim against the state of Michigan. And that's true both as a matter of statutory law and common law in Michigan, and that's true in Michigan regardless of whether the claim seeks prospective relief or damages. As to when Merck's claims accrued for purposes of 6431, the Court of Appeals reasonably concluded that the wrong being addressed here is the Sanchez decision itself. Merck has not alleged an ongoing series of wrongs committed against Merck, giving rise to independent causes of action for Merck. With that, I'll waive the remainder of my free fire time. But turning to that first question of whether 6431 applies, Pike held that 6431 generally does not apply to claims against individual state actors, relying on primarily the distinction between 6419 and 6431, noting that 6419 refers to state officers, employees, or volunteers, and 6431 applies to the state. So the court in that case held that the gross negligence claim against the university employee at issue did not come under 6431. In City of Mount Pleasant, the acting director of DTMB then, the Court of Appeals distinguished Pike, explaining that an official capacity claim is in fact a claim against the state for purposes of the statute. So then turning to Merck's argument here, Merck relies on Pike now to argue that his claims against the governor are not subject to the statute, and that is a new argument on appeal that was raised below, which is concerning here with the Court of Appeals in Pike and in City of Mount Pleasant have already been considering the nuances of this issue, but didn't have an opportunity to do so here due to lack of preservation. But regardless, Merck relies on Pike, doesn't address City of Mount Pleasant, but does acknowledge in a footnote in its brief that official capacity claims are generally claims against the state, but relies on ex parte Young principles to argue that a prospective relief claim is not actually a claim against the state.
Counsel, I just want to jump in on opposing counsel's argument about solitary confinement, or something that maybe continues to happen, but that we're supposed to lock in from the first moment. I mean, if something is arguably challenged on constitutionality, why would we lock it in at the first time that harm happened. I mean, this court has looked at things that, and deemed things unconstitutional well past the 3 years limit, so.
Yeah, I think, Your Honor, that's where the unique nature of these particular claims come into issue, because Merck is not arguing that the governor or the state is somehow taking action against Merck under the Sanchez policy. Merck is always arguing that the Sanchez decision itself is causing institutional harm, that because of this case, it can't refer clients to private counsel and it's getting inundated with calls. And so if Merck was somehow having its rights as an institution consistently violated by the state, then yes, that would be consistently giving rise to independent causes of action that would accrue new claims. And so similar with a person held in solitary confinement, they are having their rights consistently and repeatedly violated by the state, and so a cause of action is continually accruing. So we don't disagree that an ongoing series of wrongs gives rise to independent causes of action. We're just arguing that Merck has now alleged an ongoing series of wrongs committed against Merck. So just briefly, Your Honors, on the textual question of whether this is a claim against the state for purposes of the statute, I think the ex parte Young question here is an interesting nuance, and so I want to explain briefly why that the ex parte Young fiction shouldn't be read into the statute. And that's because the ex parte Young fiction was necessary because of the 11th Amendment, which required that the state could never be sued in its own name. And without that 11th Amendment in Michigan, where the state can be sued in its own name in appropriate circumstances, that fiction has no role to play. And practically what that fiction would mean here is if the Young fiction is read in 6431, then a claim for prospective relief against the state itself or a state agency would be subject to the statute, but a claim against a state officer in their official capacity, which is for all intents and purposes the exact same claim, would not be subject to the statute. And so for that reason as well, I don't think we should read this as the legislature reading the Young fiction into 6431. And Your Honor's argument on accrual, again, is simply that there's not an ongoing series of wrongs here. There is one wrong being alleged, and that's the 2003 Court of Appeals decision, which began causing Merck actionable harm, beginning either in 2017 when they began receiving calls related to the Sanchez decision, or 2019 when they had to hire additional staff. And so then the 2021 claim was untimely.
What's your response to the argument that harm renews itself each time they get a new case involving this same situation where someone's denied coverage under workers' comp, and now they've got a new client, a new case that they have to work on and spend their resources on?
Your Honor, I think it's important to distinguish, as this court has in cases like Sunrise Resorts, an ongoing series of harm and an ongoing series of wrongs. And so here we acknowledge that Merck has alleged ongoing harm, that they are continuing to incur institutional costs, but there's no allegation of ongoing wrongs committed against Merck. And so, there might be wrongs in the general sense that Merck has alleged. If Sanchez was wrongly decided, then every denial of benefits under Sanchez would be in some sense a wrong. But it's not a wrong committed against Merck, giving rise to an independent cause of action for Merck. That would be different from maybe an individual who's being repeatedly denied benefits. Each instance there is a wrong committed against that individual, and they'd have cause of action every time. Your Honor, unless there are any other questions, I will rest and with the rest of my time.
Thank you.
Thank you.
Justice, if I want to pick up where you just left off, I understand that the state wants us to have filed a case against Sanchez. That would be an easier case for this court to decide. That is not the case we filed. We think the governor's misreading Sanchez, but our case is about the fact that she continues to enforce her reading of Sanchez despite intervening changes in the law from both the U.S. Supreme Court and this court. Again, this case is no different than if she chose to ignore Lawrence v. Texas and tried to enforce anti-sodomy laws. That's exactly what she's saying she can do. And what we say explicitly in our complaint is that that policy means that the The private bar will not take these cases. If the policy disappeared tomorrow, if she chose to follow the law tomorrow, Merck would not get these deferrals. This is explicitly a decision by the governor to maintain this policy and a decision by the state to argue here that the governor can do that and try to hide behind some legalese about a prior decision. And this is on a complaint to you, right? So you need to take these allegations as true. We haven't been able to introduce into the record, but I can tell you, not in the record before you, that we have an email from officials saying this is their policy, this is what they're continuing to do, this and that we can then explain that that policy directly relates to the private bar's decisions and how Merck receives intakes. That is the case before you on a complaint that must be taken as true. That is the case we've alleged, not the one the governor wants us to have alleged, and therefore that case must be allowed to proceed. There's nothing novel about this case. When government officials act unconstitutionally, they can be held accountable. This is a case in which an entity is receiving costs. Whether the governor wants to contest whether those costs are properly caused by its policy, that's a standing issue. It's actually a federal standing issue. It's not a Michigan standing issue. They can't really raise that in Michigan court. But if they wanted to, that's a standing issue that's not before this court. But again, we allege that that causation is true. On City of Mount Pleasant's an unpublished Court of Appeals decision that provides no analysis for why this state should mean the governor, unlike Pike, which is a published Court of Appeals decision that explains why this state does not mean the governor. The only textual support the governor has given for why this state should mean the governor is to point to other statutes that say sometimes officials can be this state. And Justice Kavanaugh, to your earlier question, I think that provides further textual evidence for why the decision to focus on this state and not officers supports that the legislator knew what it was doing. It indicates that sometimes officers can be assumed as the state, and therefore if they wanted to encompass officers within the statute, they logically would have done so looking at these other statutes. But you don't need to go that far. The Court of Claims Act itself distinguishes between this state and officers. Finally.
Well, I know your argument obviously is that this is prospective relief, the statute doesn't apply here. Could the legislature implement a statute that covers prospective relief, or is that just impossible?
I guess I'm not clear, Justice Welch, whether your question's about under sovereign immunity or under a statute of limitations. Under sovereign immunity, no, they couldn't. They can't do that. There's no 11th Amendment issue here. This is about the tripartite separation of powers that's in the Michigan Constitution. The courts can say what the law is. That's Bowserman 2. That's Progress Michigan. But if they try to pass a statute of limitations that cover prospective relief, there would be two questions. One is that reasonable? And I think there would be a very difficult argument for why it was reasonable, that you could try to prevent people from bringing cases about harm in the future, but I think that would be the argument they could make. Can I finish my answer? The other question would be, is it consistent with the tripartite system of government? And again, I think that would be difficult, although theoretically possible. Thank you very much.
Thank you. Case will be submitted.